In today's video, we will talk about criminal appeals. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know how a case goes through the appeals process after a defendant gets convicted of a crime. We will talk about what types of errors from the trial can be appealed. We will also discuss the procedural steps in an appeal. We will touch briefly on other types of post-conviction relief that are different from appeals. First, the scope of appellate review. The appellate court can only look at things that happened in the trial court. They cannot bring in new witnesses, new evidence. They can only review what happened at the trial court. Appellate jurisdiction involves mandatory appellate jurisdiction of some cases and discretionary appellate jurisdiction of others. The vast majority of cases on appeal are discretionary, meaning that the Court of Appeals has the discretion to allow the appeal or not. There are 5 different types of review in criminal cases. There are questions of law. There are mixed questions of law and fact. There are questions of fact decided by a judge. Questions of fact decided by a jury, and discretionary decisions by a judge. On questions of law, the standard of review is de novo, meaning they hear the issue anew. There is no deference given to the trial court on review of questions of law. In other words, the appellate court doesn't automatically assume that the judge applied the law correctly. The test is plenary review of a legal issue for a second time with no deference to a prior decision. Examples of questions of law on appeal are whether a judge erred in interpreting a statute or whether hearsay evidence was properly admitted or excluded at trial. Then we have mixed questions of law and fact. The standard of review in this type of appellate issue or this type of issue on appeal is a mixture of de novo and clear error. The level of deference is moderate rather than none. The test is underlying factual findings are given substantial deference, reviewed for clear error only, but the legal consequences of those facts are reviewed de novo. For example, whether a suspect was subjected to custodial interrogation and whether a defendant knowingly, intelligently, and voluntarily waived a constitutional right. When the appellate court is reviewing a question of fact that was decided by a judge, the standard of review is clear error. The level of deference to the trial court is high. The test is that trial court's factual findings are to be upheld unless they are so clearly erroneous that they have no support in the record. Examples of questions of fact decided by a judge include whether a criminal defendant is competent to stand trial, or whether a criminal defendant is guilty beyond a reasonable doubt in a bench trial. The fourth category of appellate review question is questions of fact decided by a jury. The standard of review is reasonableness and substantial evidence. The level of deference is high. The test is that a jury's decision will be upheld if it is reasonable in light of the evidence in the record, and support for the jury's conclusion is adequate. Examples of questions of fact decided by a jury that might end up on appeal and be reviewed are whether a criminal defendant is guilty beyond a reasonable doubt, and whether a defendant has proved their insanity by clear and convincing evidence. And finally, discretionary decisions by a judge might have been alleged as error and be reviewed on appeal. The discretionary decisions by a judge have the standard of review of abuse of discretion. The level of deference is very high. In other words, the appellate court will defer to the trial court with a very high level of deference. The test is the trial court's decision will be upheld unless arbitrary, capricious, or manifestly unfair in light of any reasonable justification under the circumstances. Examples of discretionary decisions by a judge that might end up on appeal include whether a judge abused their discretion when denying a continuance, limiting the scope of cross-examination, or refusing to dismiss a juror for cause. The steps of an appeal: the party who's not happy with the verdict or sentence from the trial will file a notice of appeal. They will have the appellate court record prepared. Each party will prepare and file appellate briefs. Then there will be oral arguments in front of the Court of Appeals, not in the trial court. And in the Court of Appeals, it's multiple judges who hear the oral arguments. The panel will reach a decision, and one of the judges will be selected to write the opinion, and then there will be a disposition of the case. Post-conviction review is actually different from appeals. Post-conviction review can be collateral attacks. They can be filed only by those in custody. So if someone is out on probation or parole, they cannot file a post-conviction review request. They may only raise constitutional defects. These cases tend to be broader than appeals and involve things like habeas corpus. They can bring up issues that were not raised at trial in a post-conviction remedy request. They can assert constitutional protections raised since trial. They can contest the conditions of confinement, and they are unlimited in the number of these post-conviction review requests that they can file. Rather infamous are what are called the request for habeas corpus based on green jello versus red jello. I know this sounds trivial, but these things actually happen where people will be in prison. They will file a motion for habeas corpus and ask to be released from prison because they claim it violates their Eighth Amendment rights because of inhumane conditions of confinement, because they received green jello in their meals instead of red Jell-O. Not kidding, I actually worked on one. I didn't want to, but I was appointed to it. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. And the higher these videos are in the results, the more people I can help. Thank you. So habeas corpus petitions are for federal prisoners. They may seek relief if the sentence imposed violates the Constitution or state laws, if the court did not have jurisdiction to impose a sentence, the sentence imposed was in excess of the maximum allowed for the offense of which they were convicted, or if the sentence is otherwise subject to collateral attack. Another type of request for relief that prisoners file are seeking habeas corpus relief or a direct appeal based on a wrongful conviction. I know this makes for good stories in novels or on the news or in TV shows or movies, but really, how frequently does this happen? Since 1989, there have been a total of over 300 inmates exonerated, and exonerations based on other reasons. In 2016 alone, there were nearly 150. That sounds like a lot, but when you consider the fact that there are over 10 million non-traffic violation arrests every year, this is not even a drop in the bucket, but it is a good thing that wrongfully convicted people have a means for relief. So why are there wrongful convictions? One of the primary reasons is eyewitness testimony. Few things are more compelling to a jury than someone who gets up there on the stand in trial and says, I saw it happen. The defendant is the person who committed the crime. I saw it. Problem is, although the juries are so convinced by eyewitness testimony is one of the most unreliable forms of evidence. Eyewitnesses misidentify people at a shockingly high frequency. Also, there might be false confessions for various reasons. The police might have relied on unreliable informants. Forensic science is not perfect. It can make mistakes. And justice professionals can get tunnel vision, can get fixated on something, and they might also, on those occasions or in other situations, commit misconduct to get the conviction. And sometimes defense representation is, frankly, inadequate. State courts of last resort. Usually, the state court of last resort is called the state Supreme Court. That is not the name for it in New York, but it is the name in most states. The state Supreme Courts vary vastly on how they handle death penalty cases. Also, state high courts often serve as policymakers, and they apply U.S. Supreme Court decisions, and they interpret state statutes, especially evaluating the constitutionality of state statutes. Another note about state courts of last resort: most states, in fact 40 states and the District of Columbia, have trial courts and then an intermediate court of appeal and then the state Supreme Court or the state court of last resort. But there are a handful of courts that only have the trial court and their state Supreme Court or state court of last resort. They do not have an appellate court as the intermediate level. The U.S. Supreme Court is currently 9 justices. They have all been appointed by various U.S. presidents. They are appointed for life. Rarely a U.S. Supreme Court justice will step down. It's usually for health reasons. Different Supreme Court panels have had different criminal justice policy. For example, the Warren Court in the 50s and 60s made major developments in civil liberties. Different Supreme Court panels have had different criminal justice policy. For example, the Warren Court in the 50s and 60s made major developments in civil liberties. The Burger Court, headed by Justice Burger from 1969 to 1986, was more conservative, but still not that different. They didn't change things drastically from the Warren Court approach. The Rehnquist Court was pragmatic but conservative. And the Roberts Court, which has been in action since 2005, is more conservative than the several of the previous Supreme Courts. Their decisions of the U.S. Supreme Court do tend to swing back and forth like a pendulum, from more conservative to more liberal, back to the middle, and then more conservative or liberal. These changes in the criminal justice policy of the U.S. Supreme Court tend to reflect major political movements in the nation. Public opinion does impact the lives of the Supreme Court justices, and public opinion can sometimes influence the justices and indirectly limit them if they tend to go too extreme in their decisions. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students are the main audience for these videos, as well as people working as paralegals or in the criminal justice field. But everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called the IRAC method. That's IRAC. IRAC.